Welcome to Kanooni CHARCHA. Today I am going to discuss a recent judgment of Supreme Court of India. It was pronounced, delivered on 19th of September 2024, 2 days back. Its title is Sushma versus Nitan Ganapati Rangole and others. It is a, a case of negligence under Motor Vehicle Act, and accordingly a claim petition was filed by the claimants, by the petitioners, against the truck owners, truck owner and insurance company. And obviously the driver was also implicated. Its driver was also implicated as a party respondent. What are the facts? I will tell you yours in brief. A truck trailer having 14 wheels was standing in the middle of a highway at night without having warning sign, any signal for averting or otherwise avoiding any accident. Unfortunately, a car wherein passengers, petitioner heaven, were travelling collided with the stationery truck, this trailer, and afterwards the passengers boarding the car died. Thereafter, claim petitions were filed before the Motor Accident Claims Tribunal having jurisdiction. Thereafter, the matter was heard. The petitioners only impleaded the owner, I will repeat again, owner and the insurance company of the truck trailer as a party respondent. Virtually, claim petition was filed against them and not against the car owner or the insurance company, the concerned insurance company of the car. And then award was assessed, compensation was assessed. However, this Motor Accident Claim Tribunal reduced the compensation to 50%. It was observed, a finding was drawn, conclusion was drawn by the tribunal, presiding officer of the tribunal, that there is a contributory negligence in the accident, in the incident, out of which the claim petition has risen. This petition has risen and negligence has occurred. That is a 50% of the car owner, car driver owner, you may say, and accordingly insurance company, but they were not impleaded as party respondent. Obviously, the truck trailer owner and insurance company was directed to pay the awarded amount, but that awarded amount was reduced to 50%, but was assessed by the tribunal. Against this order, the petitioners, the claimants, went into appeal under section 173 of Motor Vehicle Act. You might be knowing that the claim petition is filed under 166 of Motor Vehicle Act before this Motor Accident Claim Tribunal. This is in appeal. The order of the MACT was upheld But to the extent, particularly to the extent of contributory negligence, however, anyhow, the award was reduced, compensation award, but contributory, this finding 50% contributory negligence on the part of the credit driver and reduction of award accordingly was upheld. This finding was of the MACT was upheld before the Honorable Supreme Court of India. They firstly, while exercising their jurisdiction, their lordships have first decided a point when there is a concurrent finding, whether that can, regarding factual aspect of the matter, can be disturbed. Concurrent finding of the, obviously there is a concurrent finding of MACT as to contributory negligence of the driver, and accordingly 50% this amount of compensation was reduced, and this finding was upheld by the Honorable High Court. Now, the Supreme Court of India, by referring the judgments, have drawn a conclusion. In short, I will, otherwise this episode will go long. As upheld, this made a finding, not upheld, may I correct myself, they have said that they bear the finding of the this maybe concurrent finding appears to be ex facie, apparently this perverse, where the appreciation of evidence has not been done in accordance with law. So reappraisal can be done by any superior court. Here, the Supreme Court of India. This is, so then they intervened and appreciated the finding as to this finding as to how, whether the finding drawn by these two courts, this court of MACT Tribunal and Honorable High Court, is based on the real appreciation of the evidence regarding the facts. Then they have made their own, they have taken assistance of two judgments, this Sukhviri Devi versus Union of India and another Mekala Shivaiya versus State of Andhra Pradesh. Now, para 15, in which they have, in view of the above precedents, this is the interpretations as done, it is clear that this court, in exercise its jurisdiction under section 136 of the Constitution of India, has power to interfere. But I have verbally said this is available in this para 15 of this judgment. Even if the courts below have concurrently reached to a common conclusion with respect to certain factual aspect, subject to condition that such a conclusion is so perverse that no reasonable person could arrive at such a conclusion, even if evidence was taken at its face value. Okay. Apparently, the appreciation of evidence is not in accordance with law, not in accordance with the reasonable understanding of a person, a prudent man, you may say. This is the, then after recording this finding, they entered into this, they appreciated this finding of the trial court as to factual aspect. Finding of this reappraisal of the touching factual and legal aspect, the Supreme Court of India, their lordship have referred, have mentioned, that the parking of the trailer truck in the middle of the road of the highway is in violation of the sections 121, 122. You will find the detail of this in para 28, 29. That the parking itself of the trailer in the middle of the road, by abandoning the this truck trailer in public place. And the public place is also defined in previous para. Now they have 127(2) have also been, this section has also been discussed. Keeping abandoned, unattached, wrecked, burnt, or partially damaged many. Rule and regulation of 1989 have also been discussed. The now para 34 seems to be relevant, and in view of the above discussion, the view expressed by the High Court that if the driver of the car had been vigilant, this is reappraisal of the evidence, evidence by the this High Court, uh, had been vigilant and would have driven the vehicle carefully by following the traffic rule. This is, I have already mentioned before you verbally. Now, in para 34, you will find the similar finding of the Honorable Supreme Court of India, their lordship. The accident may have been avoided is presumptions. This is a presumption on the face of the car. This is a hypothetical this situation has can be created by the this lower courts, in Honorable High Court and the tribunal. The presumptions on the face of record as the same is based purely on conjectures and surmises. Nothing on record indicates that car was being driven at any excessively high speed or that driver failed to follow the traffic rules. Such a reference is not contained either in this order judgment of the in appeal of the Honorable High Court or of the tribunal. The High Court recorded an incongruous finding that if offending vehicle had not parked on the highway, this is hypothetical. This decision they have, the accident would not happen even if car was being driven at very high speed. Therefore, the reasoning of the High Court on the same issue of contributing negligence is riddled with inherent contradiction and is paradoxical. This is Supreme. The courts now, para 34, have conclusion is drawn. The courts below odd in concluding that it is a case of contributory negligence, because in order to establish contributory negligence, some act or omission which materially contributed to the accident or damage would be attributed to the person against whom it is alleged. Mean against the, in the present case, against the car driver. There is nothing on account of contributory negligence as per the their lordship available in the evidence of the evidence led before the this now led before the MACT and appreciated by the this tribunal as well as with the High Court. Now, para 40 seems to be also relevant. On a holistic analysis of the material available on record, it is established beyond the pale doubt that a offending truck was parked in the middle of the road without any parking lights being switched on and without any markers or indicators being placed around the stationary vehicle so as to bar the incoming vehicular traffic. This omission by the person in control of the said truck trailer was in clear violation of the law. I have also referred in subsequent in proceeding paras, they have referred that this is violation of particular section, relevant sections of the motor vehicle. The accident took place on a highway where permissible speed limits are fairly high. In such a situation, it would be imprudent to hold that driver of the vehicle traveling through the highway in the dead of the night in pitch dark condition would be able to make out a stationary vehicle lying in the middle of the road within a reasonable distance so as to apply the brakes and avoid the collision. The situation would be compounded by headlights of the vehicle coming from the opposite direction and make the viewing of the stationary vehicle even more difficult. Thus, the conclusion drawn by the courts below, the driver of the car could have averted the accident by applying the brakes, and hence he was equally negligent and contributed to the accident on application of principle of lost opportunity is explicit, perverse, and cannot be sustained. The concurrent finding of the tribunal as well as High Court was found explicit, perverse, and was held not sustainable in the result of. Hence, it is a fit case, blunting exercise of this court's power under Article 136 of Constitution of India, then to interfere with the concurrent finding of the case. Now, now there is another by the negligence of a car driver. Now we go to that extent. Passenger can be held liable vicariously for the negligence, even if it is a contributor in which car he is traveling. In the present case, this cannot be done. This is also a viewpoint taken by the. Now, para 42, I will read out. As a consequence, the deduction of 50% of compensation awarded to the appellant claimant on account of contributory negligence attracted by the tribunal and found by the High Court cannot be sustained. Means the finding based on this contributory negligence on the part of the car driver, and accordingly reduction of 50% of the this assessed compensation has held bad in law, is not in accordance with law. Resultantly, it is directed that there shall be no deduction from the compensation payable to the appellant claimant, who shall be entitled to full compensation as assessed by the tribunal and modified by the High Court by the impugned judgment. This is the correct. It is further directed the respondent number 2, insurer shall be jointly and civilly liable along with owner of the offending truck to indemnify. Virtually, what happened that the contributory negligence as was found by the tribunal and the Honorable High Court, and concurrent funding was there with regard to this contributory neglect. It was set aside by the Honorable Supreme Court of India by invoking its special jurisdiction, extraordinary jurisdiction, in terms of Article 136 of Constitution of India. Accordingly, the claimants were held entitled to full compensation as assessed by the tribunal. However, it was modified to some extent by the High Court. The Honorable Supreme Court of India has found the truck trailer driver, trailer owner, and the insurance company liable for paying the full compensation. And he is found totally negligence by this parking, abandoning the trailer truck in the middle of the road of the highway and without any warning signal in order to avert some accident. And this is today's episode topic I have discussed. This is sufficient, I think, for today. Again, I will join you. Thank you. Thank you. Thank you very much.